Good afternoon, everybody. Thank you very much for joining us today. We'll go on to the introduction slide. Andrew, if you can hear me, thank you so much. So just to introduce from our side, for those of you who don't know us, I'm Alison Horner, I'm Head of Direct Tax at MHA, and today we have our speaker, Andrew Thurston. Andrew heads up our Customs Duty service line. He's got 22 years experience within HMRC, so he's a very good person to have on your side now that he's on this side of the fence. So trends and issues that we have been seeing since Brexit and day one is that businesses have just been coping and taking the hit on EU VAT, customs duty that maybe have gone wrong, customs duty that shouldn't have been charged. And businesses it's been sapping people's margin, Brexit, customs duty and VAT. And customs compliance subsequently has become very important post-Brexit because it was a seismic event for UK businesses that were trading in Europe and trading with Europe. And now businesses have got imports and exports to deal with and movements across a custom border, which is leading to cost and also a much higher level of compliance. And those of you who've been dealing with customs will appreciate the amount of paperwork and how difficult it is to unwind an import once it's happened. What we're finding now is that businesses have got their head above the water now. They're looking to have compliant processes in place. They're also considering the future and strategizing about issues such as, do I need to set up a subsidiary in Europe to cope with trading in Europe, for example? They're also looking and beginning to realise the issues that we're seeing, Incoterms and delivered duty paid, particularly, which Andrew will talk about, gives rise to all sorts of issues relating to import VAT risk. We're seeing origin, where duty is being charged when maybe it doesn't need to be, valuation points and transfer pricing, and of course, VAT leakage in Europe. So that's what we're seeing at the moment. We'll let you know what we're going to be talking about today and the contents of our webinar. We're going to be talking about, or Andrew's going to be talking about importers' obligations, what HMRC look for, how they police things, what you can do to help manage your compliance, and that import VAT risk that we talked about. We will have question and answers at the end, so please do drop any questions you've got into that Q&A function. And we also have a few polls along the way, which Andrew will tell you all about. So over to you, Andrew. Thank you.
Thank you, Alison. Good afternoon, everybody. Yeah, I'd like to just start off with this particular slide because this is the UK import declaration. This is the prime document that businesses need to receive and understand, because if they're not dealing with the data that's provided on these declarations, then they could be subjected to HMRC activity and potential penalties, customs duty fines, etc. So it's important to understand that this is the document that businesses should be receiving, and making sure that somebody in the business is looking at it. And that's what we'll talk about today. So if we firstly look at importers' obligations and what is expected of businesses who trade across borders from a UK perspective. First of all, we've got a quick polling question. So how confident are you that your business is complying with UK customs legislation? So if we'd like to take a few minutes to, or a couple of seconds to do the polling, and we can have a look at the responses. Thank you. Okay, if we'd like to sort of take a look at the the result.
Andrew, we have 74% who are confident, 9% very confident, 13% not sure, and 4% not confident.
Okay, so there's a significant number of attendees that are very confident that they are complying with customs legislation. So that's interesting. So hopefully by looking at this webinar, you'll understand whether you are in that position. Okay. So first of all, with importers' obligations, there are potential risks. So if you've not got the sufficient knowledge within the business, there are chances that the data that's being declared to HMRC is incorrect, and that will result in potential customs debts and penalties. Knock on with that is that if you don't understand the duty liability, that'll have an onward effect on how you determine the costs for your onward sales. So if you're factoring in that your goods being imported at 0% duty, but HMRC established that the commodity code being used is wrong and it should be 6% duty, that obviously has a knock-on impact with the sort of profit that you're calculating for your onward sales. So it's an important part of making sure that the whole process is operating effectively. And if HMRC do determine that there are issues with a business, they could take an interest in the other tax affairs of the company. So if there's an issue with customs, they feed that into their system, and it could result in a VAT corporation tax audit at some point in the future. So it's important to make sure that businesses understand their sort of risks involved in not having any processes in place. In terms of the expectations, HMRC want to ensure that businesses understand what its customs responsibilities are. So if you're importing and exporting goods, it's not just a matter of, well, we'll move the goods across the border, we'll arrange for the agent to declare the goods on our behalf. You are obliged to make sure that the customs declaration is accurate. And the amount of times that I did a customs audit and the importer just said, well, the freight agent deals with all that for us. It's not the case. The agent will do the declaration for you, but in 99% of the times, the importer will be under obligation to HMRC to make sure that that information is accurate and will be subjected to any customs debts and penalties. So making sure a business has satisfactory knowledge and understanding is key to complying with customs regulations. As part of that knowledge, it's making sure that the processes are in place to check the accuracy of the declarations. So making sure you get the paperwork in the first instance and that there's an awareness of what the declaration is, what it looks like, what needs to be checked, and evidencing that's key. And take the necessary steps to make sure that you're not sort of doing anything that could be considered to be fraudulent. As a business, you might be thinking that everything's going okay, but it's making sure that there isn't anything that you're doing inadvertently that could be being dealt with fraudulently within the business. And HMRC expects you to have those sorts of controls in place. And finally, be responsible for knowing which rules apply to your import operations. So if you're importing goods that are iron or steel, it's making sure that you understand whether there's any quotas that are applicable or additional tariffs that are applying. Also, if you're exporting goods that are subject to rules of origin, that you have the relevant information available. So if you're doing certain things, you need to make sure that you are fully au fait with the obligations relating to those goods that you're importing, or if you're operating a customs procedure such as inward processing, that you know what you need to do, make sure you do it at the right time so that you can comply. So moving on to what do HMRC do to police the actual customs in the UK. So we've got a quick poll. So has your company received a HMRC customs audit in the last 3 years? So if you could just answer that one for me, that'd be great. Okay, so if we could look at the results for that one, Sarah.
Absolutely. So we've got 49% no, 15% yes, and 36% not sure.
Okay, that's interesting. So the majority of the attendees have not had a customs audit. A few of you have, but it's the not sure that's obviously interesting, because it's somebody in the business will obviously have been contacted. So it's just having an awareness of if somebody in your company has been involved in a customs audit, that the people that need to know do actually get informed. There is an expectation within HMRC now that directors and company senior management are involved in the process or have an awareness of what is going on. So if you're senior to the business and you're not sure, it's worth asking the question. It may be no, but again, it's making sure that you are aware that HMRC have taken any action on you. But in this case, there's only sort of 15% that have actually been subjected to an audit. In a lot of cases, that may be due to COVID, but we are seeing the activities increase as HMRC start to ramp up their audit activities. So how do HMRC police customs? So there's a number of different elements to it. Firstly, there's a risk-based approach. So they have a risk scoring system, which has a number of different points to it. So on the right-hand side, you can see it's based on compliance with other taxes. So like I mentioned before, if you've had a VAT inspection and as part of that inspection, they found issues with compliance, that might feed into the system and generate a customs audit purely based upon the result of that VAT inspection. So that's something to consider. The size of the business, if you're just doing 1 or 2 imports in a 12-month period, it's less likely that you're going to experience a customs audit. But obviously, if your business suddenly starts to increase its import activities, that will put you on the radar. And it's certainly with Brexit, businesses went from potentially 0 import activity to a high level of import activity. And we are seeing HMRC doing audits purely based upon the Brexit effect. And looking at businesses who have been importing and certainly their first 6 months of activity in 2021 to make sure that everything was being carried out accurately. The next point is if HMRC have issued an authorization, so for example, authorized economic operator, inward processing, there's extra obligations on a business to make sure that they comply. So they would be project driven. So you might find that every couple of years you get an audit purely based upon the fact that you've got an authorization. And finally, intelligence. So if there's intel that's been provided to HMRC related to a particular type of import, an arrival point, even a business, then that intelligence feeds into the risk-based process, and that could generate an audit on your business. Following on from that, there are profiles. So the import declaration system allows for a profile to be set against certain parameters, and that could be anything from a particular commodity code or commodity code in conjunction with a particular rule of particular origin, come from a particular destination. Also, it could be specific to an importer, so there might be a profile on a company's EORI number, which we've seen in the past, and that sort of links in with the inland clearance checks, which I'll talk about in a moment. With mutual assistance referrals, this relates to trade agreements. So the UK has got obviously a trade agreement with the EU now. As part of that agreement, the mutual assistance referral process exists. So, for example, if a company in the UK exported goods to Germany under a commercial invoice with a statement on origin, claiming that the goods are UK originating, the German authorities could send that invoice back to HMRC to check that the rule of origin that's been applied is valid. So you could receive an audit purely based upon the fact that that's been checked or queried by German customs. So I think that's certainly an area that is going to increase in the near future as the EU start to want to police the trade agreement. So if you're exporting goods to the EU and you're putting down the statement on origin, it's worth making sure that you do have all the backup paperwork. Next is the UK Border Force. So if they're doing frontier checks and they find that there's a particular consignment that is worth looking at in more depth, or they suspect that the importer is doing something fraudulent, that feeds into the process and that could generate an audit by HMRC. The inland clearance checks. So HMRC have 2 inland clearance depots at the moment, one for air freight, one for container or road freight. So if a profile set against a particular commodity code or business, that would generate a movement to an inland clearance depot. So that would involve HMRC's staff looking at the goods, inspecting the goods, checking that they meet the paperwork and that the declaration is accurate. And that process could take up to 5 weeks. And we've seen businesses being held up with a number of consignments which affect their supply chain considerably, purely because of this process and the fact that their EORI number's been put aside as a profile. So it's just making sure that the paperwork is accurate and you don't get caught up in that. And finally, the Trader Support Service, and this covers specifically Northern Ireland. So if you're exporting or sending goods to Northern Ireland, there is a requirement at the moment to complete a TSS declaration if you're the importer into Northern Ireland. We are seeing that businesses are being contacted by HMRC to make sure that they're doing things correctly. Certainly when you're dealing with a declaration for not at risk, saying the goods are not going to leave the UK customs territory, and how that links in with the UK trader scheme. So if you're dealing with those sorts of movements and you're not too sure, then it's certainly something worth considering questioning a bit further, just to make sure that you've got the satisfactory evidence, because HMRC could raise an assessment for that duty if the correct evidence isn't there. So what is a customs audit? So a customs audit is something that HMRC have to do prior to leaving the EU. It was a requirement for HMRC to do on behalf of the European Commission. Now it's a UK-based situation. So HMRC have increased their auditing capabilities over the last 12 to 18 months, and we are seeing a number of clients that are being affected by that. It is possible for customs to complete an audit every 3 years. That greatly depends on the type of activities, the risk involved, any authorizations that are in place. But theoretically, HMRC could audit every single importer every 3 years. And this is because HMRC can only, under normal circumstances, go back 3 years to issue an assessment. So generally speaking, they will look at the last 3 years worth of imports rather than go back to when you started importing. And obviously at the moment with Brexit, they're still within the 3-year period. So that's why they're potentially focusing more on those types of audits at the moment. And finally, audits can be time consuming. When I was doing auditing, it would last between 3 months to 2 years, depending on the complexity of the audit, the issues that were identified, trying to get paperwork, raising any assessments, and closing that case. So if we look at this as a typical example of a customs audit and the sort of process that we go through. So a UK importer receives a contact from a HMRC officer saying that they want to complete a customs audit. As part of that process, that will involve looking at import declarations or export declarations going back up to 3 years. The importer will have to provide the required paperwork, so purchase orders, invoices, etc. Once that information has been examined, HMRC can identify if there's any errors. So if we say in this particular instance, HMRC identify a customs debt on the use of an incorrect commodity code, resulting in a debt of £150,000 worth of duty. If they get to that point, HMRC will raise a right to be heard letter, which then gives the importer 30 days to submit a response or provide further information. If that information is received by HMRC, they'll review that and determine what the final debt may be. So it might be that they withdraw the whole debt or amend it or just continue with the existing debt. Once they've made that, they issue a decision letter, and the post-clearance demand, or a C18, is issued to the importer, which is required to be paid within 10 working days. Now, that's not the end of the process. There is a right of appeal, and if necessary, you can go to tribunal. But as you can see, that process is a number of different steps. As part of that, there's communication between HMRC and the importer. So, like I say, the audit can take considerable time and effort on both parts just to get this resolved. So in terms of the common risk areas that HMRC will look for and identify, the first is tariff classification. So things like incorrect commodity codes, that result in an incorrect duty being paid, potentially the avoidance of anti-dumping duties, which in a lot of cases are considerable. So if we take the import of bicycles, for example, that could be up to 38.5%, and also affects the rules of origin. So it's important to make sure that the commodity codes are accurate. Next stage would be valuation, so looking at any additional payments relating to those goods, where you're a related company, annual pricing adjustments and freight costs as well. So if there's any additional payments that are liable to be declared, then they are generally missed by the importer. With origin, it's making sure that there's sufficient supporting evidence. So common area is that there's a lack of that, which would result in an incorrect claim, and duty would be payable by the importer. With special procedures such as inward processing, customs warehousing, there is a requirement for the authorization holder to maintain a satisfactory audit trail. If that's not there, then there might be an incorrect removal. There'll be a customs debt on poor compliance, and worst case scenario, that authorization is revoked by HMRC and the company cannot reapply for it for 3 years, creating a significant issue for the business. And finally, a new one with the Trader Support Service. Like I said, it's for movements to Northern Ireland. HMRC are looking at this, so if there's a failure to submit a TSS declaration, that could pose a risk to the business. And also with the not at risk, it's making sure that you have the satisfactory evidence for that particular consignment. So what can you do to manage your customs compliance? So if we take this as a sort of an example, you've got a consignment coming from China to the UK. So first part of it, purchase order is raised by the Chinese company. The UK buyer confirms the landed price of the goods by including any storage, import freight and customs duties. The goods are imported and customs cleared by the freight agent, with an import duty being paid at 2%. So what can you do to increase your compliance? Well, the first stage that we tend to recommend is that you look to review the commercial invoice that's provided, make sure that your supplier is putting all the relevant information on, because that would be what the agent will use as the first port of call to make sure they declare the correct information. But also customs clearance instructions. So if you've got an account with the customs agent, then you can ask that the goods aren't cleared until you provide instructions. Generally, that will result in an email being provided by the agent saying, we've got this consignment, can you just confirm what needs to be declared? That's an additional control that makes sure that you can provide correct information. You can see a copy of the invoice, just to make sure that you avoid having to do any major post-clearance controls. Once the declaration has been made, it's making sure that you do check the customs declarations and confirm that the data is accurate. So having those particular points in place are what are sort of, certainly the last part is expected by HMRC. And if that isn't being completed, then there is a significant risk that the declaration may be inaccurate or is not picked up by the importer, and HMRC could raise a significant customs debt for the last 3 years. So it's important to manage this process on a risk-based process time frame. So what can I do to manage my customs compliance. So firstly, ensure that you've got key personnel who have sufficient customs knowledge. Just don't expect the customs agent to know everything and do everything correctly. They're only declaring the goods based upon the information they have at the time of clearance. So if there's anything that's slightly wrong or they have to guess, there is a chance that that information will be wrong. So having somebody with the right knowledge in the business and understanding of what is required is key to complying with the customs legislation. That follows on to reviewing and implementing a compliance process. So if you've not got a process in place now, it's sort of recommended that you do review what you're doing, what paperwork you've got, and setting up some sort of process to look at things like standing data. So if you keep commodity codes on your product files online, making sure that they are reviewed and checked on a regular basis, that correct information is provided to the customs agent, like clearance instructions, and that you maintain satisfactory records so that if HMRC do a customs audit, you can pull out that information quite quickly. It avoids delays, it reduces your time in having to produce paperwork for the audit, and speeds the process along. And ensure that you've got the correct origin established. So if you're exporting goods to the EU, for example, you have all the backup information so that you're not going to be subject to potential risk of failing the rule of origin. And finally, have management checks in place. So if you've got personnel that are doing the actual customs checking, it's still worthwhile having an overall management review to make sure that process is effective, it's being completed correctly, and that it's reviewed on a periodic basis to make sure that there's no changes to customs legislation that may affect what is being done. So in terms of a quick example, you've got raw materials imported from around the world that's created into a finished product exported to the EU. The product is declared as UK origin on the invoice. So in terms of the controls, it's making sure the commercial invoice contains all the customs data, so EORI, commodity code, origin, etc. That once you get a copy of the export declaration, that's checked to make sure that it's accurate and that evidence of origin is retained for 4 years. Everything that's declared for import is now onto CDS. So as an example on the right hand side, the CDS report that's on the right hand side is not legally binding. So under the old system of Chief, it produced a C88, that was a binding document. CDS is supposed to be a paperless system. It's not at the moment, but eventually you will be able to access the import and export data online. But at the moment, this report is the only one that will enable businesses to sort of check against the physical paperwork. You can obtain MSS import data if you're doing significant amounts of imports and exports, but there is a charge for that that's separate. But it's making sure that you do complete routine or targeted checks on a sufficient percentage of your imports and maintain the records of those checks. So it's all very well doing the checks, but if HMRC do an audit on it, they want to make sure that you can evidence that you've done those checks, mark that the declaration is accurate, what action you've taken if you found any errors. So by having a process of control, you manage that compliance, and it also reduces the time that you need to spend on the audit. There are a couple of other things that you can get from HMRC, so I'll talk about those just briefly. The advanced tariff ruling. So if you wanted to if you're having problems with a commodity code or determine a commodity code for a product, you can apply to HMRC for an advanced tariff ruling. That lasts for 3 years and is binding, so it's an appealable decision. So if you disagree with it, you could appeal against it, but that would save any issue with classification if it was examined at a customs audit. Same with advanced origin ruling. If you're looking to confirm the origin of goods that you're importing, exporting, you can apply for an advanced origin ruling. And a new one that's just come out recently is the advanced valuation ruling. And this is specifically applicable really to businesses that are part of a worldwide organisation. So if you've got transfer pricing arrangements in place, it may be a good way of determining that what you're doing from a customs import valuation perspective, that's being correctly applied. So that's from a customs perspective. One of the areas that we've certainly seen going since Brexit is to do with the import VAT and the additional postponed import VAT accounting and the hidden risk that relates to that. So with import VAT, this changed. The policy was enforced harder in the UK back in 2019, which meant only the owner of the goods is eligible to reclaim the import VAT. And this is a specific issue with Brexit with DDP imports, whereby the importer is the seller. And I'll sort of talk about that in a moment. So DDP is the prime risk for this. You know, PVA statements are online. They're not posted to a business, unlike the C79 documents that were used to be issued by the Postal Service. They're downloadable. So if you're not expecting to be declared as the importer, you're unlikely to download these statements, and that would result in the VAT return being incomplete. So just a quick polling question. Do you receive or sell goods using a delivered duty paid Incoterm? Just a quick yes or no. Okay, so Sarah, what were the results of the poll on that one?
We have 59% yes and 40% no. Sorry, they've just changed. 60% yes and 40% no.
Okay, interesting. That's a lot higher than I was expecting. Okay, right. So this is a sort of a key area then for businesses that are on the webinar. So in terms of the VAT risk, with the DDP Incoterm, if you agree that with the seller, it places all the obligations onto the seller. So the seller would be responsible for all the formalities we're dealing with, the export from the EU and the import into the UK. Basically meaning that on import into the UK, the seller is the owner of the goods. They're the ones that can reclaim any import VAT. They should be declared as the importer, pay any customs duty, import VAT, and that would put the requirement on them to VAT register and charge UK VAT to the UK buyer. What we're seeing at the moment is that's not, in a lot of cases, not happening. The buyer is being declared as the importer without their knowledge, and with PVA statements and even now with C79 statements being only downloadable, the importer or the UK buyer isn't aware that they've been subjected to this potential VAT risk. So if you're a company that is receiving goods under a DDP Incoterm, it's making sure that you are not being declared as the importer. Check your PVA statements or go online to check the PVA statements. Likewise, if you're a seller under DDP, making sure that you have the understanding of your obligations in the importing country and that you've got your VAT registrations all set up. So in this particular instance, you've got a commercial invoice raised stating the DDP Incoterm, but with the buyer stated as a consignee, and this is a common area that we've seen. It's the UK companies declared as the consignee, which the UK import agent assumes without looking at the Incoterms in too much depth, because DDP has been one that's only been used since Brexit. The agent would declare the UK buyer as the importer. So the PVA is used without permission and the VAT is hidden. So the UK buyer doesn't realise that they've actually been subjected to this VAT charge. No VAT has been charged by the EU seller either. So there's no real VAT on that supply. So the UK buyer has non-reclaimable VAT because they have to put it on their VAT return because there's a PVA statement, but technically they can't reclaim it. And the EU seller is obliged to register for UK VAT. So that's it from a PVA position. So Alison's going to talk to you about trading in Europe.
Thanks, Andrew. As Andrew just mentioned about import VAT, it's just worth taking a moment to remember that all of these compliance regulation that Andrew's been talking about and responsibilities, if you are selling DDP into Europe, exporting your goods from the UK, importing into Europe, then you have exactly the same responsibilities in Europe. And one of the key issues that businesses have found in doing this type of supply chain to Europe is actually getting an agent to represent them, because you need to have an indirect customs representative to act for you. And the reason that it's so difficult is because indirect representation means that that agent has joint and several liability for your customs duty and VAT problems. So that's why it costs a fortune and it's difficult to get a hold of people. So knowing what the VAT position and the duty position is really important, because it might be that in that country they use import VAT deferment or they use postponed VAT accounting. So that de-risks it for the agent. It may be that the goods are UK origin and there is no duty to pay, but that hasn't been bottomed out, which again will de-risk it for that agent. But do bear in mind that that DDP term, and also if you're buying goods and selling them in Europe, will give you VAT issues as well as the import responsibilities and duty. So the VAT leakage that we're finding is happening an awful lot for our UK businesses in Europe is all about, say you've done DDP, you've imported it into Europe, the agent has charged you back import VAT, you can't claim that back. It's a lost cost to you because you're selling in Europe. You need to be registered for that in Europe. Same goes if you're buying in Europe and selling in Europe. You may have found that your suppliers have said, have you got an EU VAT number? Of course you don't anymore, unless you're registered there. And if you're registered there, they could treat it as intra-EU trade. If, say, you're buying in Germany and say you're sending the goods to your customer in France, that would be intra-EU, providing you're registered for that, there would be no VAT charged by that German supplier. But obviously, importing and selling in Europe brings with it VAT obligations and import responsibilities. So please do bear that in mind. A conversation we have a lot now that people are strategizing and thinking longer term is, okay, I've now got on top of Brexit, do I need an EU subsidiary? And a simple answer from a VAT person's point of view is, if you're selling goods, importing or buying and selling in Europe, no, you don't need a fixed establishment or an EU subsidiary for that simple trade position. You may need it for other reasons, such as conformity or labelling or other commercial reasons, but for pure VAT reasons, no, you don't. If you're registered for VAT in a European country because of your supply chain or imports, the next question is, does that create a fixed establishment for tax purposes? Again, the answer is no, it doesn't, as long as you don't have employees on the ground. If you're just, got some space in a warehouse, then that's unlikely to cause you any problems for fixed establishment or tax purposes. So just wanted to mention that, because VAT leakage, not being able to claim that import VAT back, having penalties for non-VAT compliance, that becomes a big sort of problem in the longer term. And we're certainly seeing businesses who they've borne it for a couple of years, but trade's now getting back up to speed in Europe, and it's now a cost that can't be absorbed easily. So that's it from me on trading in Europe, Patrick. Thanks.
Okay, thank you, Alison. So just in summary then, there's a number of key points. So obviously PVA is a real cash flow benefit, but you need to instruct your agent to be able to operate that for you. So if you're not using PVA, we do strongly recommend that you consider it, just to make sure that you're not paying any VAT on your import declaration. In addition to that, just making sure that you do download the statements from the .gov website. The same with the C79s. They're now online, so just making sure that that process is being completed. Conduct a review of your last 3 years imports and exports. So if you've not done it already, obviously if you've been impacted by Brexit and you're importing, it's worth making sure that you do review your import and export activities. Obviously with imports there's a tax risk, and it's making sure that you've got the processes in place, that you've identified if there's any issues, because if you do a voluntary disclosure, or you might even be due a duty reclaim, you know what your tax position is. It speeds the whole audit along if you do get an audit from HMRC. To be able to facilitate that, you can get MSS import data. So that's through the .gov website. You apply for that. You can also get it going forward, and that's a cost per month of £20 plus VAT. But it's the data that HMRC use to do a customs audit. So it's in the same format. You see what they're seeing, and it's a good key way of doing a high level analysis of your imports and exports, just to make sure the data is accurate. The next point, checking UK customs tariff. So the commodity codes do change occasionally, generally at the start of the year, but duty rates, tariff quotas, those sorts of things are all online. So if you're dealing with certain goods that you think might change occasionally, it's worth keeping a routine check so you can keep your systems up to date. Doing a routine check on customs declarations, so going forward, making sure that you do a percentage check and have a process for being able to do that, like we've discussed earlier. Reviewing the benefits of customs procedures. So you might be importing goods for manufacturing, but a lot of those goods, finished goods, you actually export. So it might be worth considering things like inward processing. Likewise, if you're bringing in goods for loan that you don't own, you may have to consider temporary admission. Otherwise, there is a significant VAT risk in addition to any customs duty. So we've certainly seen businesses that need to consider that. Commercial invoices is a key area that we've seen issues with. So reviewing the commercial invoices that you issue and also receive to make sure they have all the information, because the agents are going to use those to make the declarations. I touched on it before, but when you're dealing with fast parcel operators, certainly air freight, it's making sure that if you've got an account with them, that you do request that they provide clearance instructions to give you an element of control over what they're declaring on your behalf. And finally, looking at contracts, so ensure that you've got the Incoterms correctly reflecting how you want to trade, and that you understand what those Incoterms mean for your business and the customs risks that are associated with that. Okay, so thank you for participating in the webinar, and if we've got any time for questions, that's now. Thank you.
Andrew, there are a couple of questions that have come in, and we can go over by a couple of minutes, and we will get back to you if we haven't answered your question. The first one, Andrew, is how do people get help with the rules of origin, which are very, very complex?
Okay, yep. So firstly, you need to establish what the commodity code is. So if you're exporting a finished product, say for instance to the EU, you need to know what the commodity code is, because the first 6 digits are used for the rule of origin. So within each trade agreement, there will be rules of origin. So for the UK EU one, there's a particular specific annex that you go into, which will detail the rule of origin for that particular first 6 digits. If it relates to animal or food products, then there'll be some form of wholly obtained. So they have to be produced in the UK or EU. But for industrial goods, it will be a percentage or a change of tariff heading. So the first port of call is to check the tariff to make sure your commodity code is correct, and then look online for the EU UK EU trade agreement. Obviously, if you've got any issues with particular rules of origin, we are obviously available to provide any assistance for helping you get that information, determine the rule of origin, and advising on the type of evidence that you need to retain and provide to your agent.
Andrew, we'll do one last question. Have there been any significant admin changes for UK to Northern Ireland importers other than signing up for UK internal management market, UKIMS, and labelling? Is there anything else that people should be aware of?
Obviously, the UKIMS came in from the 1st of October. So businesses that have got UK Trader Scheme and haven't applied for the UKIMS need to do so now, because the UK Trader Scheme is no longer valid. But at the moment, it is purely just looking at, so if you're trading goods that aren't subject to sort of phytosanitary certificates and things like that, then it is purely the UKIMS, and making sure that you are compiling the commercial records ready for next year when the red and green channels come in. If you're dealing with animal and food products that need to have export licenses and things like that, then it's making sure that you understand the rules and obligations relating to those, just to see if there's any changes. Obviously, the labelling with the not for EU is an important factor, and making sure that you've got that on your products at the right times, because there is a staged process starting from, I think, the 1st of January next year.
Thanks, Andrew. Well, thank you very much, everybody, for joining today.